We turn our attention at this hour from the business desk to developments around Sipho Pityana and Absa. That's as the entity's former executive is demanding the bank's board meeting minutes. That's following the alleged interference by the Reserve Bank's Prudential Authority, which is said to have blocked his candidacy for the Absa board chair position. Mr. Pityana joins us live now virtually. Thank you so much for your time, Mr. Pityana. Now, this matter is ongoing. I'm interested in finding out really what are you looking for in the board meeting minutes, especially because this issue is one that is dubbed as contentious, and you do note that you are entitled to have those particular notations.
Well, good evening to you and the viewers out there. This is a very important issue because it's about transparency, which we expect of all in society. It is commonly known that I have challenged the decision of the Absa board as a result of unlawful interference by the Reserve Bank to object to my recommended appointment as the chairman of the board. And the Absa bank, against whom I am seeking no relief through the courts, decided to enter the fray and have introduced new information in a dispute that is otherwise between myself and the Reserve Bank, without providing supporting evidence as is required in terms of the procedures of the courts. So all I'm doing is I'm asking them to provide the minutes of the meetings that they have referred to. There are 12 of these, and they have released redacted versions of some of those. It leaves one in a position where I'm not therefore able to competently respond to their affidavit without the benefit of that information, which is about the deliberations of the body that took decisions in that regard. And the court will not be able to deliberate on those either, because it has to base itself on facts. As it happens, the affidavit by Wendy Lucas-Bull has contradictions with that affidavit that has been provided by Kuben Naidu, who is the Reserve Bank Deputy Governor, who was the Prudential Authority at the time. So the only way to clarify all of that is to go to the deliberations of the Absa board and make that information available. This is standard practice. They are arguing that I'm trying to expose the former chair of the board, Wendy Lucas-Bull, that she may have lied to the courts in her affidavit. That's not my purpose. My purpose is to just enable the court to get to the bottom of the issues, and that's what the court is asked to do.
And of course, it is an ongoing matter, and you filed this application for those board meeting minutes. Has there been a response from Absa?
Well, Absa has responded, and it has indicated that the minutes are not necessary because in its reply to the court, it has not based itself on the minutes. I mean, it's preposterous that anybody would say that the meetings that took decisions on this matter, the minutes of those meetings which are referred to are not relevant. And they're arguing that they are not relevant. They're arguing that they are confidential. They're arguing that it's not necessary to produce this. Certainly, there is evidence to show that in the past, the courts have been able to compel entities to do the same. I hope that the court will come to the same view that Absa is obligated to provide those in order to ensure that the grounds are even, the scales are even for those of us who are participating in this dispute. The second aspect, of course, you know that I'm also challenging Absa for removing me as a director on the board. That the law allows for a review of that decision. What it means is that the record of decision by the Absa board must be the subject of scrutiny by the courts. And the only way in which I can present an argument to say this is where they erred in respect of this in coming to their decision, and allow the court to scrutinize that is to actually have the benefit of what was a recorded conversation between myself and the board. And by the way, I'm surprised by all this resistance by Absa to make this available, because they gave me an undertaking that they are recording our deliberations because it will be required by the courts when in the event that I decide to go for a review. And they promised that they would furnish me with a recording of a conversation that I was part of. And now they're refusing to make that available, and they're arguing that it's not relevant.
I would like to also find out about what really is at the essence of you pursuing this matter on a principle, integrity, as well as transparency element of the argument. It has been dubbed and described as a corporate fallout.
Well, there are some very important issues around this matter. The first one is that regulators have to work within the framework of the law. They are law enforcement agencies. Parliament passes laws and assigns powers to regulators and various agencies. They have to work strictly within the framework of those laws. And there's a very good reason why those laws are crafted in the manner that they have been. And secondly, private companies also have to honor the rule of law. We, as business, always insist that we must promote an order in society which is about the rule of law. So if you have no less a corporate like a blue chip business like Absa, seemingly condoning and endorsing violations of the law that are so blatant, it casts serious aspersions about good governance and our commitment to good governance. And from my point of view, it is important to shine the spotlight on this. And the purpose of my challenging this is because I am aware that this is something that the Reserve Bank does on a regular basis, and it's important that it be exposed and have the court. That's why I've asked the court to issue a declaratory order that the conduct of the South African Reserve Bank and its Prudential Authority has been unlawful, so that there is clarity in terms of what the parameters of the Reserve Bank are and its conduct, and that is not allowed to circumvent the law. It's independent, and it must be independent of the banks. It is quite clear that we need to rein the Reserve Bank in from a sense that it can act wantonly without any accountability. Nobody is above the law in this country. We're a constitutional state. The law is supreme. That means all of us are subordinate to the law, including the Reserve Bank. The second one is that, I'm not an employee of Absa. I'm an independent, non-executive director. And there's a very good reason why, in terms of our governance framework, we have moved from companies that are run by a clique of people who are buddy-buddy to a notion of independent directors. So if the board removes me for merely challenging the unlawful conduct of the Reserve Bank, that must be unlawful, and that's why I'm challenging their decision to remove me from the board.
Lastly and briefly, Mr. Pityana, I must ask the timing of this debacle and you speaking out. There's been question about why now, and having served on that particular board as a non-executive member and other boards, why is this matter being raised and fought so fiercely this time?
Well, I've been on the board of Absa I was on the board for 2.5 years, and during that period, I've used my opportunity to raise issues. That's what directors do. You raise issues in the board, and you win some battles, you lose others. And I believe that the environment on the boards should be permissive of independent directors to do so. The reason why this has come in the open in the manner in which it has is because I've taken advantage of the fact that the law that governs banks allows and gives me the authority to, in a situation where I am an affected party, to take the matter through the courts. It's a very rare opportunity that is not readily available in respect of other aspects of board deliberations. So the Reserve Bank has acted, in my view, unlawfully Absa board knows that this is so, and they've decided that they don't want to offend the Reserve Bank in its unlawful conduct, so they've decided to exercise as a board their prerogative to not do so. It doesn't take away my right in law to challenge that unlawful conduct by the Reserve Bank, and that's exactly what I'm doing.